What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody, and welcome in to another episode of The Lawyer You Know. And we are breaking down this Idaho 4 case again. And thank God today it's actually a legal document we're talking about, not some side story or somebody said something who used to know somebody or we're speculating about some conspiracy theory. We're talking the law. The state has responded to the defense's discovery requests. And as we look through this document, we're going to talk about a couple things. We're going to talk about what we know, what we don't know, and what we might know or what could be there that we're not really sure from this document that a lot of people are talking about. We're going to talk a little bit about the rules of discovery in Idaho and what may or may not have to be produced. But let's get to it. Hit that like button if you enjoy the Idaho content. If you enjoy any of the content on any of the cases we're handling, whether it's this case, the Murdoch case, the Vallow Daybell case, whatever it may be, make sure you subscribe so you can get involved in choosing the content that we break down on this channel, because you, the viewers and the subscribers, get to pick that content. So make sure you subscribe and like the video if you enjoy this kind of content. So here we go. We are looking at the state's response to requests for discovery. Comes now the state in the above title matter and submits the following response to the request for discovery. The state has complied and will continue to comply with such requests by providing the following. So it's not just a one-shot deal. They're not going to necessarily provide every single piece of information or documents that may respond to these questions today, but they will continue to supplement and supply this discovery as it becomes available, as they get a hold of it. They'll continue to give it to the defense. Number one, any relevant written or recorded statements made by the defendant or copies thereof within the possession, custody, or control of the state, the existence of which is known or is available to the prosecuting attorney by the exercise of due diligence, and also the substance of any relevant oral statements made by the defendant, whether before or after arrest, to a peace officer, prosecuting attorney, or the prosecuting attorney's agents, have been or will be disclosed or otherwise made available. See Exhibit A. Couple things that we're going to learn just from question number one. Number one, we're going to see this language in the possession, custody, or control of the state, the existence of which is known or is available with due diligence. So we either know, or it's easy for us to get, or somebody under our control has it. But we're not saying we know everything at this point, and we may still learn certain things. There may be some things out there that we can't get that we will try to get and try to use. Okay. So the only things here are what we have or what's easily accessible for us. Number two, you're going to see just about everything is in Exhibit A. Great. Look, I'm going to scroll down to the bottom and here's Exhibit A. Oh, this is the last page. So we don't actually get to see all the stuff that they produced, but we're going to learn a lot from Exhibit A. Exhibit A, police reports and documents covered by ICR 16, which are in the possession of the state, have been disclosed to counsel for the defendant as of January 23rd, 2023. These materials consist of, so first, the defense has these materials. They've gotten a lot more information on January 23rd than they had before. Okay, that's number one. The defense has a lot of information now. Number two, what we've looked at, 19-page document, 50-page document, a couple pictures here and there, we have basically nothing, less than 10% of the stuff just referenced in this first data dump. Because as they said, they'll continue to comply. They'll continue to supplement. And we're talking about pages 1 through 995. So basically 1,000 pages. One video and 1 through 1,865. So almost 2,000 photos. So we're talking about almost 3,000 documents, photos, videos, types of pieces of potential evidence that has been turned over from the state to the defense, which tells us we don't have anywhere near all of the information, but the defense has a lot more of it now. And maybe we will learn a lot more and see a lot more of this in June during that preliminary hearing. And Andrea Burkhart reached out and she said she may be actually going to that preliminary hearing and she may come on the show and discuss what happens there. We'll dig into it with her. I love the way she does her work. I love the way she digs in. I love the time she takes. I love how she focuses on the law and the legal angles and not all the other hyperbole and other stuff. So that would be cool if she could come on and discuss it further. All right, let's get to number 2. Any written or recorded statements of a co-defendant and the substance of any relevant oral statement made by a co-defendant, whether before or after the arrest in response to the interrogation by any person known by the co-defendant to be a peace officer, agent of the prosecuting attorney, have been or will be disclosed or otherwise been made available. See Exhibit A. So this was the big one when we saw the actual requests. There's a co-defendant? Well, first off, they don't necessarily confirm or deny that there is a co-defendant. They could have just said NA, not applicable. There is no co-defendant. They didn't. Okay, so that's one thing. Obviously, we know they haven't charged anybody else. Were there any potential co-defendants or anything like that, or somebody that already pled, maybe that we didn't know about and they're keeping it under seal? I don't know. They also didn't say, as they say in number 3, defendant's prior criminal record, if any, has been or will be disclosed or otherwise made available. They didn't say if any with the co-defendant, right? So people are going to speculate, but I don't necessarily think there is a co-defendant. But they didn't put it to bed, which they theoretically could have here. Number 4, any books, papers, documents, photographs, tangible objects, buildings, or places, or copies, or portions thereof, which are in the possession, custody, or control of the prosecuting attorney, and which are material to the preparation of the defense or intended for use by the prosecutor as evidence at trial or obtained from or belonging to the defendant, have been or will be disclosed or otherwise made available. So this is all the stuff that they took from the defendant that they may use as evidence. And it's in Exhibit A, which we can't see. In addition, deputies and officers from the Latah County Sheriff's Office, Idaho Police, Moscow Police, Idaho Fish and Game, or other law enforcement agencies may record law enforcement contacts via an audio recorder or audio video recorder. So they bring somebody in, they may record that interview, could be on body cam, could be on a hand recorder. Any audio and video recordings related to this matter are available for review and duplication on request, subject to the provisions of ICR 16. Pursuant to said subsection, and except as otherwise specified herein, any such digital media is unredacted and may contain protected information. Thus, further distribution is restricted by the rules, unless the state provides express written consent or by order of the court. So what does this mean? They're going to turn over some stuff. Some stuff is going to be available for the defense to come review and maybe even duplicate. But there will be plenty of things that are unredacted and privileged or can't be distributed the way the defense is asking for. And so they're not going to distribute it unless they get a court order. So the defense will see some stuff. They'll be able to duplicate some stuff. Other stuff they won't be able to see until a judge says so, or if, the state obviously provides written consent. So the 3,000 pictures, documents, videos, that's still not everything, because that doesn't include a lot of what law enforcement has from interviews and recordings that they're not turning over yet, that they may allow to be reviewed, duplicated, or even produce in the future. So there's still a lot more coming. Any results or reports of physical or mental examinations or scientific tests in the possession, or if they can get it pretty easily, is made available in Exhibit A if they exist. Number 6, a written list of names and addresses of all persons having knowledge of relevant facts who may be called by the state as witnesses at the trial has been or will be provided separately in accordance with ICR. So even more stuff coming separately. Any record of prior felony convictions of any such persons which is within the knowledge of the prosecuting attorney, and all statements made by the prosecution witnesses or prospective prosecution witnesses to the prosecuting attorney or the prosecuting attorney's agents or to any official involved in the investigatory process of the case have been or will be disclosed or otherwise made available. Consistent with Ramirez and Idaho Public Safety and Security Information System, restrictions on dissemination of criminal history information, the state generally does not seek NCIC reports or Spillman reports of witnesses. Additionally, the state may call as witnesses anyone otherwise identified or referred to in reports, statements, or other documents referred to in this response. So we're going to give you the stuff that we have on the witnesses we may call, but just to cover our butts, anybody's name that's mentioned anywhere in any of the documents, any of the interviews, any of the reports, that's fair game as well. You should be on notice if they're mentioned anywhere else throughout the discovery process, basically. So they're covering everything. Number 7, a written summary or report of any testimony that the state intends to introduce pursuant to these rules of the Idaho Rules of Evidence at trial or hearing have been or will be disclosed. Now, this response does not necessarily include disclosure of expert witnesses, their opinions, the fact and data they for those opinions or the witness's qualifications intended only to rebut evidence or theories that have been disclosed under the rule prior to trial. So they're basically saying, we don't know who all our experts may be. We could have more experts. We don't know what their opinions are. We don't necessarily know what facts and data they're going to rely on. So that may come in the future. So this list may not include all of them. Number 8, any reports and memoranda in possession of the prosecuting attorney, which were made by any police officer or investigator in connection with this investigation, prosecution, have been or will be disclosed or otherwise made available. See Exhibit A. All material, this is number 9, or information within the prosecuting attorney's possession or control, which tends to negate the guilt of the accused as to the offense charged, or which would tend to reduce the punishment, therefore, have been or will be disclosed or otherwise made available. See Exhibit A. In addition, with regard to material or information which may be exculpatory as used or interpreted, the state requests that the defendant inform the state in writing of the defense which will be asserted in this case. So counsel for the state can determine if any additional material or information may be material to the defense and thus fulfill its duty under this rule. Brady. So what's your defense? Is it an alibi defense? Is it I was there but I didn't do it? Is I was just the driver? I was just an accomplice? What is your defense? Because what your defense is could affect what the Brady material is, what the exculpatory material is. And here is number 10, what everybody's been asking about. Is there an informant? Does the state have an informant against Brian Kohberger? Number 10, unfortunately, this is going to fall under the we just don't know category that I spoke about in the beginning. To the extent that information exists regarding an informant, so it's kind of an if any, to the extent that information exists. They're not saying there is an informant, but they're not saying there's not an informant. So it's a fair question. Regarding an informant who is not going to be produced as a witness, including recordings or written statements of an informant or that identify an informant, such information is not subject to disclosure, and the state asserts information privilege under ICR 16 and prays for appropriate protective orders pursuant to ICR 16.1 as necessary. So what I thought would be interesting is if we could also bring up what that rule is that discusses discovery of informant information. And this is the State of Idaho Judicial Branch Supreme Court. This is the Idaho Rule, Criminal Rule 16. So when you see ICR throughout this document, this is what it's talking about. And we are going to go to G2. G2 is what we're looking for. That's C, E, F, G. All right. 1 is work product disclosures are not required. But number 2, informants. Disclosure must not be required of an informant's identity unless the informant is to be produced as a witness at a hearing or trial, subject to any protective order under subsection I believe that is, or L, I can't tell, of this rule, or a disclosure order under subsection B6 of this rule. So, what does this mean? This means there very well could be an informant against Brian Kohberger who is giving information to law enforcement and to the prosecution, and they could have gathered evidence based on what that informant told them, and we may never know who that informant is because they may never call him as a witness at a hearing or trial, but they may use the evidence that they gathered based on something the informant told them. Now, if he was going to be or she was going to be a witness, then they would have to disclose this information. But because at this point, it doesn't seem like they're going to be a witness, even if there is an informant, this isn't confirming that there is one, but it is an interesting discussion based on the state's responses. Number 11, the state objects to request by the defendant for anything not otherwise addressed above on the grounds that such requests are outside the scope of ICR 16 and or are not subject to disclosure under ICR 16G, work product informants. Work product and informants. That's what we just looked at. Work product disclosures must not be required of, and I'll just read the rule because I'm still looking at it, a legal research or of records, correspondence, or reports or memorandum to the extent that they contain the opinions, theories, or conclusions of the prosecuting attorney or members of the prosecuting attorney's legal staff. And C is really what they're looking for. or what they're looking to protect, I should say. That last part we read. Reports or memoranda to the extent that they contain opinions, theories, or conclusions of the prosecuting attorney or members of the prosecuting attorney's legal staff. So this is basically covering everything. We're not giving you anything that we feel falls under work product or that informant exclusion. Wherever this response, number 12, indicates that certain evidence or materials have been or will be disclosed or otherwise made available, such indication should not be construed as confirmation that such evidence or materials exist. Co-defendants and informants. Let's read that again. Do these answers confirm that we have co-defendants and informants? Not so fast. Answer number 12. Whether this response indicates that certain evidence or material have been or will be disclosed or otherwise made available, such indication should not be construed as confirmation that such evidence or materials exist, but simply as an indication that if such evidence or materials exist, they have been or will be disclosed or made available to the defendant. Furthermore, any items which are listed as in Exhibit A but are not specifically provided or which are referred to in documents which are listed in Exhibit A are available for inspection upon appointment with the prosecuting attorney's office. Additionally, all property forms, chain of custody documents, and similar items are likewise available for inspection on appointment and are hereby deemed to be part of Exhibit A for purposes of this response. Pursuant to ICR 16J, if the state subsequently discovers additional evidence or evidence of additional witnesses or decides to use additional evidence or witnesses, the state will promptly notify the defendant and the court. And then we just see certificate of delivery and then Exhibit A. So we learned some stuff. We learned what we didn't know. We learned that the defense is getting a lot of information now that they have to go through and why it takes months for them to prepare for this preliminary hearing because they got to get a lot of this information over to their experts. And then we learned that certain things may or may not exist. And these documents are not giving us definitive answers, but maybe the preliminary hearing will, maybe future documents that come out in this case from the actual legal portion of it will give us real information. So we're going to keep keeping an eye on that. A lot of you sent this to me on Twitter at Tragos Law. Follow me on there. Follow me on Instagram. Send me the stuff you want to hear. When enough of you send it, I answer the call. We come and make a video. Hopefully you guys have a great weekend. Hopefully you can join me later tonight as we talk about the day in court for Alec Murdaugh and his team. Hit that like button on the way out. Thanks for joining me. I'm out of here.